Uh, Good afternoon, everyone. I hope you're all feeling fairly relaxed and ready to wind down over a long weekend. I must admit I'm filled with some anxiety and trepidation about having to spend 4 days confined at home, but I'm sure it will be enjoyable, as it will be no doubt enjoyable for everyone listening today. Thank you once again, everyone, for dialing into what is our second webinar in our program of 7 topics that we'll be covering over the course of the next couple of weeks. Obviously, today's topic will be talking about workplace issues and COVID-19. And it's a pretty remarkable day today, or in fact, probably yesterday was a remarkable day, to the extent that we had obviously last night Parliament pass a raft of laws relating to the JobKeeper program that creates new legislation and also goes about amending some provisions within the Fair Work Act. Less publicised or less something that received a lot less media coverage yesterday, though, was a decision issued by the full bench of the Fair Work Commission, which made a unilateral decision to vary a whole raft of awards, and those variations come into play very soon. So today, what I intend to cover are those two topics. We've only got half an hour, so there's a fair bit of information to cover. You'll see that what's just popped up on your screen are some housekeeping matters. So in terms of questions, obviously we want as many questions as we can have put through to the system today, and we'll try and get to answering as many of those as we possibly can. So there's a text box to the side of your screen where you can text your questions and comments using that questions panel. Carolyn from our office is also listening in today, and hopefully it will work to the extent that as we get to questions, the question will actually pop up on the screen. I'll read the question and then go about answering that. So please make sure that you put in or submit, as many questions as you can over the course of the next half hour, and we'll see how we go about answering those. I know that I've already received 2 questions from obviously very organised people, so I will attend to trying to answer those questions first, and obviously any others that come through as we go about discussing these matters this afternoon. I must admit the level of information that's coming out from the government at the moment is significant, and I haven't felt this level of intensity when it comes to trying to understand new legislation since the introduction of work choices in March of 2006. So 14 years almost to the day. History seems to be repeating itself in my life anyway. As I mentioned, the first yesterday was quite a big day when it comes to industrial relations, and so what I want to talk about are the variations to the awards and also the introduction of the JobKeeper legislation and the bills that passed through Parliament late last night. Topic number 1, the variation to the awards. So I didn't think that I'd ever really be talking about something like this, as I imagine none of you thought that you'd be listening to matters relating to industrial relations in the current environment, both health and economic environment that we have. But yesterday, the Fair Work Commission, the full bench of the Fair Work Commission, went about introducing 2 changes, or 2 fundamental changes to a whole raft of awards. Those awards are not all awards that are modern awards within the Fair Work Commission jurisdiction have not been varied, but certainly a large percentage of them have been. if there are specific requirements or inquiries that you have about these changes to the awards and whether they apply, we're going to send around a flyer about this particular topic over the course of the next few days. So the first variation is what's called an unpaid pandemic leave. So this is a variation that essentially gives employees the right to take 2 weeks of unpaid pandemic leave. So when does an employee have a right to take such leave? Well, essentially, if an employee is either required by a government decree or by a medical practitioner to self-isolate, but for that self-isolation, they would have ordinarily been available and ready to attend at work, then they can take a period of 2 weeks of unpaid pandemic leave to assist them with self-isolation. And I guess the intention of that is to make sure that employees' jobs are secure for that 2-week period. In terms of the circumstances where you have an employee who is not ill, in circumstances of where an employee who is ill, so they have contracted COVID-19 or they're displaying flu-like symptoms, then of course those people have the entitlement of personal leave or paid personal leave, assuming they've got enough accrued entitlements to continue to be able to take that particular leave, being personal leave. The second change that the Fair Work Commission introduced yesterday was the capacity for employers and employers to agree for an employee to take half-paid annual leave. So essentially what that means, if I can explain this by way of example, is that if you have an employee who wants to take 1 week's leave, but instead of taking that 1 week leave over the course of 1 week, they take it over 2 weeks. So the leave the 1 week leave is spread out over 2 weeks, is essentially what this provision is allowing employees and employers to agree upon. Importantly, with this half pay annual leave, any agreement that you make with an employee around taking half paid annual leave, that agreement must be recorded in writing. And essentially, the employee must be paid what they would ordinarily have been paid for those for that week over the course of 2 weeks, and that includes any payment in relation to leave loading. So you can't. There's no right to get out of leave loading, or it doesn't apply in those circumstances. It still applies. It's just that essentially it's paid at half rate, as is the person's ordinary pay over the course of that 2 week period. Finally, in relation to that particular half pay annual leave, the agreement that is made between the employee and employer in writing is to be retained as an employee record, as you might expect, by the employer. As I said, not every award has been amended. Certainly a large swathe of awards have been amended, and we'll aim to issue a list of those amended awards over the course of the coming days. Now, quite historically, last night we had a Liberal government pass a JobKeeper program that has many of its roots founded in a socialist system where employees and employers who fit an eligibility criteria receive the benefit of a payment from the government to enable the employer to retain the services of an employee. And this is a really unique and significant piece of legislation, not simply because of the size of the payment in terms of the overall cost to the government's baseline. But also, obviously, it's really important for ensuring the continuity of employment in appropriate circumstances. So the way the JobKeeper program is going to be introduced is really by way of two pieces of legislation. Firstly, the government has created what is a coronavirus economic response package payments and benefits bill, which will be converted to an act. So in short, the Payments and Benefits Act. That act creates, I guess, or implements the framework about which things like the JobKeeper program are to be or can be introduced, in the administration of the payment of those monies to eligible employers and employees. The other change to assist in the implementation of the JobKeeper program is a variation to the Fair Work Act. Essentially, what the bill amending the Fair Work Act does is just cut and plonk into the Fair Work Act a Part 6(4) capital C, for anyone who might be interested in the actual provision, Part 6(4) capital C of the Fair Work Act. And I'll get to discussing that in a moment, because some of the changes that have been introduced as part of the variation to those to the Fair Work Act are important. They certainly provide flexibility at a time of need, and but there, as like any workplace law, you might imagine there are certain rules and guides that the government has introduced to assist with the facilitation and implementation of those variations. But firstly, the Payments and Benefits Bill. So essentially, if I can explain the aim of the bill like this, it's to create a connectivity or to maintain a level of connectivity between employers and employees. So what the government's trying to do here, and they say this in not so many words, is that they have a theory that if we can ensure that connectivity between the employer and employee remains intact for the next 6 months, then in the event and in the hope that business is reactivated at whatever is deemed to be the end of this particular crisis, then business will be able to kick off without having to hire or find new staff to reinvigorate their business and their enterprises. So that's the aim and the theory of this particular program. As what we do, or what the bill does do, is effectively a little bit unhelpfully, I must admit, it gives the Treasury the right to make rules about the eligibility of employers and employees who can participate in the JobKeeper program. Now, that's all very well and good that it gives the Treasury the power to make those rules, but of course, the Treasury is not in a position to make those rules until this legislation becomes enacted, which I anticipate will be in the next couple of days. And so we don't have built into the legislation the eligibility rules as to who is an eligible employer and an eligible employee. All we have at the moment is what's already been circulated broadly around broadly by the government and many commentators, is the fact sheets that talk about eligibility. And those fact sheets, as most of you will probably be aware, is that if you have a business whose turnover is less than $1 billion and your turnover has fallen, or it's estimated that it will fall by 30% or more, then you are an eligible employer for the purposes of the JobKeeper program. Then once you establish your eligibility as an employer, then you have to assess whether your employees are eligible or not to participate in the program. And we know that 1 March is the key date in relation to that. So an employee who is still employed or is rehired must have been employed as at the 1st of March 2020 for permanent employees. And for casual employees, there was obviously much debate about whether casual employees, the restrictions around casual employees should be removed in their entirety or shortened, but essentially it has fallen that the casual employee must have been engaged for a period of 12 months as at the 1st of March 2020 to be an eligible employee for the purposes of the JobKeeper program. So I anticipate that beyond what we already know with the fact sheets that have been issued by the Treasury, there will be further information issued over the coming days and weeks. What's not, I think, clear, and this is something that people might consider, is if you are an eligible employer and you have an eligible employee, does the payment that you apply for, does it apply to every employee, every eligible employee within your business, or only those eligible employees that you make application for? So it might mean that some employees you make application for and some you don't. So it's unclear as to whether or not it's just a blanket application to the employer if you're eligible and all eligible employees, or whether it's only those that are applied for. What the Payments and Benefits Bill does do, though, is set out some very clear rules in relation to how a commissioner, so the establishment of a commissioner to regulate this program, appears to be being created as we speak, and there are certain issues or items, if you like, that are set out in the bill that are, for want of a better phrase, clear. And they are these. There will be specific forms, but those forms have not yet been identified, that will need to be completed in order to access the program. So you will have to provide information in accordance with a particular form to seek eligibility and to seek payment. Now, one of the other rules is that, or requirements, I should say, so we don't get confused with what we were talking about before with the Treasury rules. So the requirements, one of the requirements is that employers or participants will need to create and retain adequate records for both prepayment and post-payment of any payments made under the JobKeeper program. And in fact, if your prepayment records do not satisfy what the Commissioner sets out as the requirements in the applicable forms that will need to be completed, then regardless of whether you are an eligible employer or not, you may not actually receive payment under this particular economic response program implemented by the government. And presumably the reason for that is because they want to make sure that they are paying people who have a legitimate and genuine and real need. And essentially you will need to make sure that you have the right documentation in order to establish your eligibility. Again, we don't have any detail about what those pre-payment and post-payment records need to include, but one would assume that part of your prepayment application form, you will need to establish either the 30% turnover reduction or a trend suggesting that there might be a 30% turnover reduction. If you make application and you receive an overpayment from the government, of course, not surprisingly, that will need to be repaid. And not surprisingly, if you engage in fraud, you seek to access this payments under this program in circumstances where you're not entitled to do so, and the only reason you've been able to is because of some false misrepresentation that you've made to the government about the state of your business, then not surprisingly, administrative and criminal law consequences exist. And worst case scenario, from a criminal perspective, you could be jailed up to 12 months in the event that you fraudulently apply and receive the benefit of this particular payments under this particular program. So what we will hear and obtain further information about over the coming days, I would anticipate from the Commissioner, is information relating to the kind of records that you must have and you must keep, and also probably the manner in which you must keep those records, because I'd anticipate that all original documents would need to be retained so as to ensure some legitimacy and genuineness of the applications that are being made. So don't hesitate to send through any questions if you have any in relation to those matters. Now, moving on to the amendments to the Fair Work Act, I guess from my personal perspective, this is where it gets a little bit more interesting. And so we'll get straight into it. So as I said before, Part 6 4C, the Coronavirus Economic Response part of the Fair Work Act is going to be, as I said before, effectively cut and plonked into the Fair Work Act. Importantly, this part of the Act only applies to people who are eligible employers and eligible employees. So that means that if you are an eligible employer, and what I was saying before about you having eligible employees but you don't make application for payment or an allowance for those individuals, but for some you do, then arguably these provisions would only apply to those employees who are also eligible employees or being approved eligible employees as part of any application process. So it's really important that everyone understands that these provisions only relate to eligible employers and eligible employees. In broad summary, and we'll go into this in a bit more detail, the amendments create certain rights for employers. They create what is called a JobKeeper Enabling Stand-Down Direction, a JobKeeper Enabling Direction. So that's something different, not a stand-down direction, but an enabling direction. And there seems to be an important distinction between the two, so I'll come to that. And also the JobKeeper Enabling Direction gives the employers flexibility around directions, including everything from working fewer days or hours of employees through to where they can work, where they work, and also provisions or rules relating to certain entitlements like annual leave. And so we'll move on to that in a moment. But what we do know about the JobKeeper program, obviously, is that employees are entitled to an allowance of $1,500, or an employer put another way, the employer is entitled to receive a subsidy of $1,500 to cover the wage-related expenses associated with an employee. And as I said before, the importance of this is to maintain connectivity between the employer and the employee. So once you are in receipt of the $1,500, it's an offence under this part of the Fair Work Act for you not to pass on the full $1,500 to the particular intended recipient of the benefit in the fortnight that you receive the monies. So that means that you can't receive the $1,500, put $750 of it to the employee's wages, and then $750, sorry, to some other component of your business, with an intention to top up that $750 at a later date. That's not allowed. The entitlement is, and the expectation is, that the full $1,500 will be passed on in the fortnight that it's received for the individual who you have received that money for. The JobKeeper enabling stand down direction cannot reduce an employee's hourly base rate of pay, but it can alter the number of hours or days of work that an employee might do. So if I can explain it like this, so a JobKeeper enabling stand down direction enables you as an employer to stand an employee down, either in full or in part, for the period of that this program is in place. So that direction is important, obviously, because it allows flexibility, but it's important also to recognise that the $1,500, if the employee works during that period because of a enabling stand down direction, and the value of their work is less than $1,500, then of course they're entitled to $1,500 as the full reimbursement. However, if using the employee's ordinary rate of pay, that employee does an amount of work that the value of that work exceeds $1,500. So let's say, for example, the value of the work applying the employee's ordinary rate of pay for you over those 2-week period is $2,000. Well, then the employer in those circumstances would receive the $1,500 benefit from the government or subsidy from the government to cover a portion of that employee's wages, but the employer would then be required to top up that $500. So what that means is that you can't reduce the employee's rate of pay down to something that is less than what they ordinarily receive. And so there's a guarantee, if you like, of an employee's ordinary hourly rate of pay for calculating the value of the work that they do during any particular period. Now, I anticipate that some people might be wondering, well, I pay my employees an annualized salary, and so therefore that annualized salary incorporates a whole range of things. How do I determine what the ordinary rate of pay might be for that particular individual? Well, I guess this is where everyone might recall the introduction of the annualized salary arrangements in many awards over which commenced on, which seems like a lifetime ago, but it was only the 1st of March, I think. Where you have an annualized salary arrangement in an award, you are required to calculate or set out the methodology for determining that person's annualized salary arrangement. And so that methodology, which identifies the ordinary rate of pay of that individual, is used then as the basis for calculating the person's ordinary rate of pay for this JobKeeper program. Hopefully that makes sense. If there's any questions coming from that, please don't hesitate to send them through. So the other, so you can alter the number of hours or days that an employee might do under an enabling stand down direction, but also under an enabling direction, it gives the employer authorization to do some other things. For example, an enabling, and this is a little bit confusing because the enabling stand down direction is where you effectively stand someone down to do either in full or in part to do certain works. Where you haven't stood an employee down, but you want to change that employee's hours or days, or you want to change the tasks that employee is doing, or you want to change the location at which that employee might do their work. So this is a circumstances where the employee has not been stood down. Then a JobKeeper enabling direction allows you to do things like agree with the employee around working fewer days or hours, agree directions around what tasks are to be performed and when, and also where those tasks are to be performed. And so we'll go into that in a bit more detail now. One of the things to remember about this particular enabling direction, or JobKeeper enabling direction, is that it operates regardless of an existing what they call an existing designated employment provision. So, for example, if you have an award, a contract, some other Fair Work direction about certain entitlements, about work, when work is performed, etc. These directions that are able to be enacted and provided by an employer who is an eligible employer to an eligible employee, these provisions, these directions operate irrespective of those other entitlements, but only to the extent that this particular direction amends or varies those particular entitlements. So, for example, an employer can provide a direction about the different dates and times that an employee can work compared with the ordinary days and times of work for which they might have ordinarily done. So there's a particular useful definition in the bill or the explanatory memorandum to the bill, which says this: if an enterprise agreement permits an employer to change employee rosters following consultation, those terms continue to apply if no JobKeeper enabling direction is given about fewer or days or hours of work. The employer would still be able to change rosters in accordance with the enterprise agreement. However, if you give an enabling direction that reduces an employee's hours of work via one of these JobKeeper enabling directions, the direction applies despite any otherwise applicable enterprise term or agreement terms for the duration of the direction. So that gives some flexibility. There's a capacity to direct employees to alter the hours of work, the days of work in what is a largely confined space and for a confined period of time, but certainly you can imagine that the flexibility that provides would be very useful for employers and in anticipate and employees. What we need to remember, though, I think, is that we need to be careful about the direction that we're giving and the consequences that might flow from an incomplete or insufficient direction. So if you give a direction about days and times and you haven't thought properly through whether that impacts other issues or items relating to that person's work or their work environment, then the direction would only apply as it is given, and not affect anything else that the employee might be entitled to. So one of the tips, if I can provide one as part of this, is that I would be wanting to make sure that there is sufficient evidence about the direction that I'm giving. I'd want to make sure that it's clear and articulated and it's in writing, and there are certain rules about that. And one of the benefits of that is that it assists in avoiding disputation. The next thing is that the duties that an employee might ordinarily do as part of their ordinary work, those duties or an employer, an eligible employer, may direct the employee in relation to those duties to do something different to what they ordinarily do. And that's allowed so long as the duties that you are directing the employee to perform are safe. So it's not creating a workplace health and safety hazard. The employee is licensed or qualified to do the work that the employee has been asked or you've directed the employee to do. And the duties are reasonably, I guess this is important, they're reasonably within the scope of the employee's business operations. So that would prevent me from, example, directing one of my solicitors to mow my lawn over the coming few days, although that would be really nice. In terms of direction, so the location, if I can call it the location direction, the location of work may be changed. Sorry, I'm just seeing a note about the extension of the webinar. I know I've gone over time. My apologies for that. But there's a fair bit of information to cover. So the direction, the location of work, the location direction, the location of work may be changed by a enabling direction, so long as the place where you are directing the person to do the work is suitable. Unreasonable travel is not required. So you couldn't ask a person to go and do work in a location where travel would be significant or not unreasonable. And where you direct the people or person to do the work is safe, having regard to the various matters identified in the legislation, such as the nature and spread of coronavirus. So I'd anticipate directing an employee to work in an environment where coronavirus is likely to spread is something that's probably not allowed. Also, as I mentioned before, the day and time of work, and this is important. Because this is the distinction between enabling direction and enabling stand-down direction about the day and time of where work is to be performed. So you can direct an employee to work at particular days and times under an enabling direction, so long as it's safe to do so, and the hours that an employee performs when compared to what they ordinarily do are not different. Now, the important point about this is that this isn't a stand-down direction. This is an enabling direction to give you the right to direct an employee's ordinary hours of work. Now, an employee's ordinary hours of work under this scheme would allow you, for example, if it's reasonable to do so, to do work, for example, between the hours of 8 and 10 o'clock at night, where that employee might ordinarily be doing those hours between 10 and 12 during the day. And one example that springs to mind in relation to this is I was discussing hours of work with a butcher recently, and the butcher had to alter their hours of work because of the confined space of in which they operate. So they had essentially had to run a split shift. So they had some employees working during the day and then other employees working at night, so as to keep demand up. Now, if that employer was an eligible employer and the employees were eligible employees, then under this scheme, and by giving this direction, you could get the employees doing the same number of hours, but those hours could be between 8 p.m. at night and midnight, and no overtime or any other allowances would be paid. They would be the ordinary hours of that particular individual. And so and this is where an example of where if you gave a direction and you didn't think about the complete changes to a person's entitlements, then you might find yourself having given the direction but not confirming that, for example, that the direction was that their ordinary hours of work were to be at certain times and dates during the day, times and hours during the day, and you think that the only entitlement is their ordinary hours of work, and that may not necessarily be the case. There's also certain provisions relating to leave, as I mentioned earlier, and I think this is quite important because what it enables an employer to do is to ask an employee to take annual leave for a period of time and seek the subsidy payment from the government to cover the employee's annual leave entitlement. Now, you might have heard or read recently that this is something that Qantas is intending to do, and the unions are kicking up a stink because they're saying that, well, the government shouldn't be subsidising Qantas for having its employees on annual leave. Annual leave is an entitlement of the employee, and if they would be receiving the benefit of $1,500 even if they didn't take leave. So why would they take leave when Qantas, in the union's mind, should have set aside those monies anyway? So, and this is quite I think a somewhat contentious issue when it comes to this particular program, because it does, I guess, enable an employer to utilise the subsidy to reduce an employee's annual leave accrual and do so without therefore having to pay the employee all or potentially all or most of their annual leave entitlement. But that there are certain provisions set out in the Act about, or what will be the Act about this, and it says this taking of paid annual leave provision essentially facilitates an employee to consider an employer's request. So it's an employer requesting an employee to take paid annual leave and to agree to take that annual leave either at full or half pay. The employee must, their obligation under the Act is to consider and not unreasonably refuse their employer's request to take this annual leave, provided, and there's a caveat on this, provided that the amount of leave that you're asking the employee to take does not reduce their accrued leave balance to below 2 weeks. And so it seems as though, as I said before, an employer can request, an employee cannot unreasonably refuse to take a period of annual leave, and the employer receive a subsidy from the government, assuming both are eligible, receive a subsidy from the government to cover that employee's leave during the period. Of course, as I said before, you might find that employees are reluctant to accept or acquiesce to this request because they'd be getting the $1,500 anyway, so why would they chew up their leave balance in these circumstances? But nonetheless, it's one of the provisions that are allowed for in this new regime. So some rules. You know, as lawyers, we like rules. We like them to be as grey as possible. But in these circumstances, the rules that the government has introduced are admirably quite clear in most respects, except for the first one. It says any direction given under this JobKeeper program must not be unreasonable in all of the circumstances. So what is reasonable and what might be unreasonable in all of the circumstances? Obviously, that leaves a lot of grey area for there to be discussion, but essentially it's saying, look, we're all in this together. Don't be unreasonable. Give reasonable directions. Don't take advantage of the situation, and everything should be okay. The employer, when making a direction around any of those topics that we've spoken about, you must give the employee at least 3 days written notice of the intention to give the direction that you're intending to give. And this is where, as I've said before, having the issue in writing was a recommendation. Well, in terms of JobKeeper enabling directions, the obligation is to put it in writing and to issue the direction at least 3 days prior to the implementation of that direction. There's also a requirement if there cannot be genuine agreement between the parties for there to be consultation and a written record kept of the consultation that's engaged in. Finally, the direction that's provided by the employer has a lifespan, and it cannot be, it will be in effect until it's either withdrawn or revoked by the employer. So there's some level of control for the employer in these circumstances, or it is replaced by a new direction given to the employee. So they are the rather simple rules, if you like, in relation to JobKeeper enabling directions. And of course, as with all things in the employment environment, if there's a fight, then everyone trundles off to the Fair Work Commission to try and resolve whatever dispute might be happening at that particular moment in time. And so obviously there are provisions in the Act that deal with disputes under this particular provision of the amendments to the Fair Work Act. Finally, and interestingly, there is a provision in the Act that's incorporated as a variation to the Act that says that an employee, if they are eligible and qualify obviously for a JobKeeper payment, and they are entitled to ask or seek permission to engage in a reasonable secondary employment, training or professional development program. So if an employee, I'm stood down, I'm getting this entitlement, but I want to go and seek secondary employment, the employee is allowed to request that. You cannot unreasonably refuse such a request. I think it would not be unreasonable to refuse a request by an employee to go and work in a secondary employment role where where there's a conflict of interest between your employment and where they want to go and get their secondary employment. But nonetheless, that request cannot be unreasonably refused. What I understand happens in those circumstances, though, is despite the fact that the employee might be receiving payment elsewhere, you are still obliged to pass on the full $1,500 to that individual. So that's it. I know that there are a couple of questions that have come through, as I mentioned, and we'll quickly deal with that. So Carolyn, if you could pop up on the screen, please, the first question that came through. And this one is it reasonable to have a workplace policy that an employee must not attend the premises to work if unwell with flu-like symptoms, and they're required to have a medical clearance to say they are required to have that medical clearance to say they are fit for returning to work? In my view, short answer to that question is yes. It is reasonable to have a workplace policy because what you are doing is protecting the health and safety of the individual and their work colleagues, and you are protecting the viability, if you like, of your business. So I do not see a problem about a policy like that. What might be helpful as part of that policy is reference, if it's applicable, the newly created unpaid pandemic leave that's been incorporated into the modern awards. That might assist in facilitating this type of situation. And because of the industry that this question derived from, many roles cannot be worked from home, and so they're trying to minimise the risk, and that seems like a sensible thing to do. So Caroline, is there another question? I see there is. There's a wife and I own a business. I'm employed as an employee and paid a weekly wage. My wife, who also works in the business on a full-time basis, is paid via distributions. Can I apply for JobKeeper as an employee? And my wife applies as an employee receiving distributions. I guess the reality, it would seem, of that situation is that both persons are engaged as employees and paid an entitlement for the work that they've performed. So I do not see why both parties as employees of that particular business could not be entitled to a JobKeeper payment, so long as the eligibility criteria are met, of course. But there might be some rules issued by by Treasury, as I mentioned earlier, as part of the Payments and Benefits Bill, that might assist with the facilitation and answer to that question. So I don't think there are any more questions from what questions about superannuation. Okay, can you confirm superannuation of JobKeeper? I'm of the understanding that super is not payable if the employee only gets JobKeeper, but if the employee gets more than their entire wage attracts superannuation. Can lose if this is correct or otherwise. Is an employer required to pay superannuation if only paying? So in terms of the JobKeeper allowance itself, that is right. If a person is receiving JobKeeper only, then it is a gross payment for which you would which you would deduct your ordinary pay-as-you-go income tax withholding from that particular payment. In terms of if a person is working and they are performing work and being paid their ordinary time earnings, regardless of whether that payment is via a JobKeeper subsidy or you pay in addition to the JobKeeper subsidy, my understanding is that if there is work performed and it's deemed to be ordinary time earnings in accordance with the superannuation guarantee legislation, then superannuation is payable regardless. I think that answers questions 1 and 2. Do you have to pay if they have been stood down under the JobKeeper enabling stand down direction? My understanding to that is no, but for if you reduce their hours or days under that particular direction, then again, if the work is ordinary time earnings, as that term is defined, because they have undertaken work, then you would be required to pay superannuation. My understanding is that there's another slide to come. Parental leave. Yes. Now, this is an interesting question. The second one is there any clarity on whether employees under probation during any stand down could have their probation period extended upon returning? Both really good questions. My understanding with parental leave, are they ineligible to receive the payment? The short answer to that is no, so long as the parental leave that they're entitled to or are currently on is approved parental leave in accordance with the Fair Work Act. Now, I put a caveat on that in that I read something very late last night about parental leave, so I'll come back and clarify that particular issue. But my understanding is no, if it's normal parental leave, well then it's normal parental leave and there's no eligibility to receive the payment. Is there any clarity on whether employees under probation during any stand down could have their probation period extended upon returning? I anticipate that when you talk about probationary period, you're asking this question in the context of what is a minimum employment period for the purposes of determining whether a person has access to the unfair dismissal laws or not. So as most people probably understand, there is a provision in the unfair dismissal part of the Act that says if you are within your minimum employment period, then and your employment is terminated, then the Commission does not have jurisdiction to hear your claim for unfair dismissal because you haven't satisfied the eligibility criteria to bring an unfair dismissal claim. Doesn't mean the employee can't. Sometimes they still try, but it's just that there's a jurisdictional argument to say to the employee or say to the Commission that they don't have the right to hear it. In terms of a stand down, my understanding is that a stand down in the ordinary sense of the stand down provisions is that it does not extend the minimum employment period. And so you could technically have a situation where an employee is within loses it. For example, you're a small business employer and you have a 12-month minimum employment period and the employee is stood down for a period of 6 months, then potentially that person doesn't have, well, there's not the capacity for you to obviously assess that person's performance during that period, and nor is there a capacity for the employee to show their worth, if you like, for the business. And so in ordinary circumstances, there would be no extension of the minimum employment period. Now, I will just double check once again that particular point, because at the beginning of the amendments to the Fair Work Act, there was, no, there doesn't seem to be any, in the bill, there doesn't seem to be any changes to my understanding around that. Whether or not we see there being further amendments to or rules issued by Treasury, perhaps, that deal with some of these questions and provide more clarity, well, I guess it's a matter of waiting and seeing. Carolyn, is there another slide? No. Okay. So thank you once again, everyone, for listening. We've got upcoming webinars on the 14th, 16th, 21st, 23rd, and 28th of April, as you can see on your screen just now. Thank you, everyone, for attending and listening. Thank you, Carolyn, for being the person facilitating all of this. I genuinely and sincerely hope that you all have a very safe, restful, hopefully stress-free break over the next 4 days. Obviously, we're all instructed to stay home, so please listen to those directions so that we can all be up and running in the not too distant future. So without any further questions coming through, I'll wrap it up there. Thanks very much, everyone, for attending.